Good morning, and welcome to a session of oral arguments before the 5th District Court of Appeal. I'll first introduce the panel. On my right is Judge Jacqueline Griffin, and on my left is a visiting associate judge from the Ninth Circuit, Judge Jay Cohen. Counsel ready to proceed on the first case, which I believe is styled DYKAS, is it, versus State of Florida. Do you wish to reserve any time, sir?
Yes, just maybe 2 minutes.
Okay.
I suspect I'll have plenty of time. May it please the Court. My name is Michael Becker. I'm an assistant public defender here in Daytona Beach, and I represent the appellant here, Patrick DYKAS, in his appeal from his convictions for attempted robbery and aggravated assault. We presented 2 issues on appeal, the first being the sufficiency of the evidence to support the conviction for the attempted robbery, and secondly, the propriety of the trial court's decision to give the state's requested jury instruction. With regard to the first issue, the sufficiency of the evidence to support the attempted robbery, of course, it's important to note that the standard of review for this court is de novo in reviewing the denial of a motion for judgment of acquittal. In this case, of course, it's important to remember the facts, too. In the case before us, the defendant followed the victim into a parking garage as he was driving into the parking garage. He drove past the car as the victim drove into a parking space. He turned around and then came back and pulled up behind the victim's car.
Counsel, we're familiar with the facts in the case. Why don't you address the issue here of whether the act of pointing a gun at somebody without demanding something of value is sufficient to support a conviction for attempted robbery?
Well, of course, it's our contention that is totally insufficient. That is an aggravated assault. If that were sufficient, just pointing a gun and motioning a person to get out of the car was sufficient for an attempted robbery, every aggravated assault would be converted immediately to an attempted robbery.
Well, that isn't quite so. You've got additional factors here. You've got the fact that he followed him into a private garage, that he wore a bandana. What we're talking about here really is what was the intent of the defendant in the case. Isn't that what we're talking about?
Absolutely.
And isn't that always going to be established? Well, I shouldn't say always. Absent a statement of some sort by the defendant, either in terms of admissions to the police or otherwise, isn't that also always going to be established by circumstantial evidence?
Absolutely. I mean, well, almost always, like you said. But in this case, the circumstantial evidence is, you can have a lot of different interpretations.
Well, the question becomes whether the circumstantial evidence is inconsistent with theories of innocence. Isn't that the standard?
Theory of anything other than guilt.
Well, no. What about the Toole case? Didn't the Supreme Court address that argument in Toole when, although in a different context, they spoke about it in terms of the burglary statute, but they specifically indicated in Toole that it wasn't exclusion of other reasonable hypothesis of guilt in Toole.
And I apologize, that wasn't cited in either of the briefs, and I'm not really...
Toole was the case...
I noticed Toole, I think that's what he was referring to.
It spoke about the burglary statute and indicated that in the context of burglary, that the state did not have to prove a specific intent, otherwise burglary would intend to commit an offense, and that the state did not have the burden of excluding all other possible crimes. And isn't that what your argument is that the state, in this case, failed to exclude reasonable hypothesis of guilt in other contexts?
No, I don't believe so. In the context of the burglary statute, one of the essential elements is that when you enter or remain in the place, it must be done with the intent to commit an offense therein. It doesn't matter what the offense is, and the Supreme Court has since held you don't have to allege a specific offense. In this case, there must be an element of the attempted robbery must be the formation of an attempt to take property which can be the subject of larceny. It must be a very specific intent.
And so a guy comes up in a car, blocks another car in with a gun and a bandana. Do we need to be rocket scientists to figure out what was going on?
Well, in this day and age, it could be a drive-by shooting. It could be just a random act of violence, a gang shooting, a gang killing, murder. It could be anything.
So
The state chose to charge this as an attempted robbery.
But under that, what you're saying is that the state didn't exclude other hypotheses of guilt, other criminal conduct. And isn't the rule on circumstantial evidence that you have to exclude reasonable hypotheses of innocence?
No, I don't think so. I think it's broader than that, because for circumstantial evidence, it must be consistent with the theory of guilt of the offense. And that to the exclusion of all other reasonable hypotheses. And I don't think it is necessary. They speak a lot of innocence, but I don't think it's limited to that. I think there is more to it than just simply it's either innocence or it's guilt. It's got to be guilt of the attempted robbery because the state chose to charge that. So they have to have something that you can point to in the record that says, well, he wanted to take something from them. It could have been, even the trial court realized, well, you're right. He could have been doing anything. We don't know. But certainly robbery is one reasonable suggestion. And yes, it is. But is it to the exclusion of all others? No. And I think that's where the problem comes in here. For whatever reason, the state chose to make this an attempted robbery. We don't have any other evidence to support that he was going to take anything other than, yes, he was wearing a bandana, but people who commit other crimes try to conceal themselves. I don't think that's necessarily peculiar to an attempted robbery situation. A lot of people point guns at things. That's not necessarily peculiar to an attempted robbery. A lot of people run when they hear a noise. That's not peculiar to an attempted robbery. Nothing in this case distinguishes what he did from an aggravated assault.
Why isn't that an issue that, taking all of those factors that you've mentioned, the alarm going off, and can't the jury take all of those things together and collectively decide that there was an attempted robbery here?
Well,
Obviously
they did. But the question arises as a matter of law, should they have been able to be given that opportunity? And we suggest no, they shouldn't. This was an aggravated assault. They found him guilty of aggravated assault on the same individual. And I think that was a proper decision. That's why we're not attacking the sufficiency of that evidence or that conviction. But there has to be something more than just...
Well, you are attacking that conviction in terms of the jury instruction.
Yeah.
Well, right. We're asking for a new trial, not necessarily the sufficiency of the evidence to support that conviction is what I was arguing.
Mr. Becker, my problem with this, or the concern that I have, I think the Fournier case and a couple of other cases you cited in your brief are of interest on this point, and I understand and really pretty much accept what you've said, except the difference in this case is that this was a case where there was an interruption of the crime. And I'm having trouble squaring the basic definition of an attempt with your argument. Here what we have is clearly, I think, an overt act, and then we have an interruption. Why isn't that enough for an attempted robbery?
Was it really an overt act and an interruption, or was he committing the crime of aggravated assault?
Well,
and that was completed upon what he did. That's completed offense.
I think that's a question of fact. We know that he was in the process of. I mean, he didn't just complete a threat. He was in the process of doing something when he was interrupted. I think as a question of fact, that's something that we can accept. And so then the question becomes exactly what? And as long as we have a pretty good beginning to an armed robbery, we certainly have an overt act that would qualify in an armed robbery, and we have the interruption by virtue of the alarm, which is what stops robberies. Why isn't that enough?
Well, I suggest here, and again, you mentioned the Fournier case, which I think you have even more evidence in the Fournier case. He went over, reached into the car, grabbed the woman, and said, "I need money." And they said that wasn't an attempted robbery. I mean, maybe that was the wrong decision, but I don't know how you square
Well, but
that.
in that case, she drove away.
That interrupted it.
Well, it was an interruption, but but this clearly was an interruption that was based on his conduct. The alarm caused him to stop.
Well, no, it's based on the victim, the same thing. The victim is one who caused the alarm to go off when he opened his car door.
Right, but,
The same as the victim drove away in Fournier.
well,
I don't really see it as a difference here. But for the acts of the victim in Fournier, the defendant didn't complete it.
In Fournier, though, the guy was begging money. And as the court stated in Fournier, he was doing it aggressively, but it wasn't, that's effectively the context, was some guy on the side of the street, begging money from passing cars.
But
You
you have a
don't
statement
think
that-
that's a little different than somebody in a car with a bandana and a gun?
No, I don't. I find it just amazing that they didn't say it was an attempted robbery.
5 minutes left.
Thank you. Because, okay, yes.
aggressive begging is different.
Aggressive begging, apparently there is an exception for the robbery. I mean, there you had a statement of his intent was to get money.
Turning to your other issue, how is it that you think that jury instruction was a comment upon the evidence?
Well, because it basically takes the question of an inoperable weapon and tells the jury, forget that. It's still a deadly weapon.
Was it a correct statement of the law?
Yes, it was, but that doesn't end it. Even a correct statement of the law can be a judicial comment, and the court held so in Fexty, which I've cited in the brief. Of course, the flight instruction was a correct statement of the law.
Well,
They found that to be a judicial comment.
You've got an abuse of discretion standard on that, and that's awful difficult to overcome, as you well know.
I sure understand that, but a judicial comment on the evidence is a clear violation of due process. And if you're violating due process, the very fundamental right to a fair and impartial jury trial by judicial comment, I suggest to you that there can be no other abuse of discretion than that.
Thank you, counsel.
Thank you.
Good morning. May it please the court. Mary Jolly on behalf of the state. It's the state's position that we presented more than sufficient evidence of the attempted robbery. I think the totality of the circumstances demonstrate that. We have the garage. It's secluded. All of those facts, but the bandana.
what if they charge attempted kidnapping or attempted sexual battery? Are we, you think that those convictions would be sustainable?
Again, we presented proof of those. I think that the difference here is, though, I think you conceal yourself when you want to steal, like you concealed his face, Judge. You conceal yourself because you don't want to be identified, which could happen in those cases as well. But the fact that there's also testimony in the record about the fact that, at 8 o'clock they were looking for hotel rooms, and then they decided they're too expensive, but then at 9 o'clock these crimes occurred. I think
Well, first of all that testimony occurs during, after the defense case. And so I think that it had properly been preserved on the motion for judgment of acquittal, saying that it shouldn't have even gotten that far. So let's not focus on the what you think the defendant's girlfriend added to the motive.
Okay, that's fine, but it does certainly support the verdict. Notwithstanding that, I do think that arguably, yes, they could have pursued those charges, but the prosecutor has the discretion on what charge they think they have the strongest proof of, and they felt they did of attempted robbery here. The ag assault happened when they showed the weapon. He could have showed it and taken off. Then he gestured them to come out. That's when it changes. And I think Judge Griffin hit the nail on the head. The only reason this crime was thwarted was because of something independent of what Mr. DYKAS did, and that alarm went off. And I think that's what makes it the overt act toward the attempted robbery. He could have ag assaulted by just stopping, showing them the weapon, and taken off. They'd have been scared. They thought it was a deadly weapon. This notion that, well, he could have been there to commit murder, well, we know that wasn't an operable weapon. So I think the concealment is key, and the fact that he flashed and gestured him to get out. He's going to steal from them. I think that a reasonable juror can infer that.
So let me ask a question similar to what Judge Cohen was asking you, and ask you to respond to his argument that, we don't know what this guy was attempting to do. He might have been attempting a drive-by shooting, or he might have been attempting assault, or, you know, we really don't know. How do you respond to that?
I think the fact that he, again, I'll reiterate what I just said, Judge, but that the fact that he could have showed the gun, there's the assault right there. They concede that. He then waves them out. What's he going to do? Now, it's an inoperable weapon, so there's no potential for murder here. Well, I mean, you know, with the
But
weapon.
this isn't a mystery to be solved. What's he going to do by simply asking that question?
And I think
It seems to me that you give credibility to the defense argument.
I think that a jury, which is presented from this evidence again, it's not rocket science. What else is he going to do but rob them? What else are you going to do late at night in an isolated parking garage?
What about kidnapping?
Yeah.
Kidnapping, he mentioned kidnapping. Kidnapping is the thing that keeps coming to my mind. There's no way that we could say that this was more likely to be a robbery than a kidnapping.
But, Judge, we have the evidence of the robbery as well. That's what we charged, and that's what we argued to the jury. I mean, we're here on JOA, and is there sufficient evidence of an overt act towards a robbery? And yes, is there sufficient evidence potentially of an overt act towards kidnapping without ripping through the elements of it? Possibly, yes. The fact that he may have had, you know, the fact that, and the jury makes the decision about intent. And we presented sufficient evidence of an overt act towards robbery. That's what we charged, and that's what's before the jury. I think there's some more than sufficient evidence to let it go to the jury, let them ferret it out. That's their role, and they make that decision. This notion of, you know, this notion of he makes no, his only defense was, well, they weren't there. Well, we have two identifications of the defendant, the car, the bandana, and the gun. This reasonable hypothesis of guilt, in his own brief, he says it's a reasonable hypothesis of innocence. He cites a case out of this court saying that is the standard. Now, well, no, it's a reasonable hypothesis of anything other than guilt of this crime. There's no case, he doesn't present any case law to support that. In fact, he cites case law to the contrary. It's a reasonable hypothesis of innocence. I think here, the evidence is right there for the jury, and it's a common sense, reasonable inference for them to draw, because they have to infer intent based upon his conduct, that this was going to be a robbery, and there's sufficient proof of that. That's the charge we decided on. I think pretty confident in that evidence and the verdict that derived from it. Unless the court has any other questions on that or issue 2, we'd ask you to affirm the judgment and sentence in all respects. Thank you.
Counsel.